happened in terms of governance, politics, and we will be looking at that. And before I introduce my panel of experts, maybe we can just try and just look at some of the things that we will be looking at. The Kenya Certificate of Secondary Education is commencing today. My colleague Joseph Wahungu will bring us up to speed with exactly how the preparations and how the exams start, mostly beginning with the languages and also practical examinations today, and also music as among the first subjects today. And today we also have a number of petitions and court cases at the Milimani Law Courts, of which we will be headed to the courts as soon as they begin, beginning from the Gachagua'S state applications hearing for orders. Last week there were about 23 petitions and cases filed in regards to impeached Deputy President Rigathi Gachagua case. But since then, they have increased to a number around 30 cases, which will be heard today. And we'll be waiting to hear what the courts have to say in regards to his impeachment. We also have the affordable housing case. Remember, this is a process that has been challenged since day one. We'll be expecting a judgment in regards to that. Some petitioners had talked about the housing levy being unconstitutional, and adequate public participation wasn't carried out. And also we will be looking at the COP29 in our subsequent bulletin. My colleague Serafina Robi is in Colombia following up on that. And allow me now to introduce my panel of experts, beginning from my immediate left, when we have Sami Kipkemboi Meli, who is a political analyst and also a governance expert. Karibu sana bwana Meli.
Asante bwana Jua.
Just next to him, we have Dr. Benjamin Koskei. Daktari is a senior lecturer at Kenyatta University and also is a leadership and governance expert. These are the two gentlemen and brilliant mind who will help us put things into perspective. My name is Bentroy Njoe. Brian Muraru is our sign language interpreter on the bottom right of your screen. Remember, you can weigh in on this conversation via all our social media platforms as we are live. Gentlemen, karibu sana.
Asante sana.
First things first, we also had Mashujaa Day just 2 days ago. And the head of state led the country, and since the promulgation of the 2010 constitution, for the first time we didn't have a deputy president to welcome the head of state, of course, in light of the events that happened at the Senate last week. And he talked about a number of things. Maybe we can start with the obvious one and the theme of that day, which was affordable housing. And more or less, he really emphasized that the project, which already has been challenged in court, he said that the project is going to be realizing a lot of houses, and especially for Kenyans. Meli, I would like you to weigh in on the president's speech.
Thank you very much, Ben Troy. On the housing issue, I think the legality or the illegality of it, since it's a court issue, let's wait and see what will be ruled out. But my own personal opinion is, one, we need housing as urgently as possible. The slums around the city and any other towns in this country are actually increasing in numbers. More people are moving to urban areas than they are in the rural setting. So it will be shameful for one to fight a housing issue because I have been one person who is disappointed early in the morning. I'm an early riser. I make it to this city by around 5:30. And you see people sleeping under the expressway, wrapping themselves in some sacks to sleep there. That shows you there's a problem of housing in this country. My main issue now is the affordability of the same. Because if a house, for example, they are talking about a studio apartment, will go at around, let's say, 800 on the list. That is too high to be affordable for a common man. Even if you were to divide that for the next 20 years, it will mean somebody will be paying around 4,500 a month to achieve that. That is still expensive. For me, I would think of something lower that is affordable, because by the time I've once before, you know, people come from somewhere. I've lived in those slums before, and you pay even 200 for a mabati shelter, even 300, 500. There are such shelters there, and those are affordable for some of the people, especially people who do manual work. They go to industrial area, they are paid, let's say, 200, 300, 500 shillings a day. Those are wages. That's not a salary. So if you look at the same thing, this is a person who has earned 300, for example, comes along the way, picks some kerosene for 5 shillings or 20 shillings, because right now if you're looking at the kerosene retailing at over 100 shillings, that tells you for the least to use per day, perhaps 50 bob. From the 300, he's left with 250. He goes to a quarter sugar. That is again around 50 shillings or so. That goes, now that's 100, remaining 250 has to go for some cooking oil, some vegetable, some unga. At the end of the day, the 300 is not there. So if you were to ask this person to pay, let's say, 4,000 a month, this person cannot save to pay 4,000 a month for a house. So it should be more affordable. I think the person who is launching a case in court, it should be about the price, not about the housing. Because I've been lucky to visit even last week, the one that is going on in Kibra. I am seeing the other phase is almost complete, and I saw people being enumerated for phase C and D. They are even being told to leave so that that place is cleared for the next phase of the housing. I've been to South C, I've seen affordable housing going on. I've been to South B, I've seen them. I have been to Mukuru, Kwajenga, I have seen those houses, and actually they look beautiful. But the question is, how affordable are they to the common man? Because at the end of the day, will it be the normal one where the National Housing Corporation used to do it, and you find the same senior people are the ones buying the same houses?
Yes.
And how sustainable is this project? Is it enshrined in law such that if we have a new government coming 2027 or 2032, the same thing will go on? It will not die with William Ruto. I am seeing, for example, this BRT things that were to be put on Thika Road. Right now it has stalled because it was Uhuru Kenyatta's project. You are looking at some roads that have stalled because it was somebody's project. I wish that we have such anchored in law such that the other person who is coming has no option but to continue with that project. Because if anything was to happen and this government goes home, that means the affordable housing project will not go on because it is this government's project. So those houses are going on, the housing projects are going on, but how informed are the people? Because I liked it being used as a theme in that in Mashujaa Day celebrations, because this is now about public information, letting the public know what is going on. Somebody was asking me and was asking weird questions, and I said, you don't know what is going on? Go to eCitizen, go to Boma Yangu, register yourself there, start saving if possible. Yes, and choose where you want your house to be. And this person was asking me funny questions. How sure am I that I'll get the house? Who will I see? I said, you don't need to see anyone. Yeah. It is already in eCitizen, every person's portal. And as they say, ignorance is no defense. Ignorance is no defense. But I'm getting a lot of propaganda that is going on online, and Kenyans are becoming gullible to propaganda that is online. Yet the same person selling propaganda online perhaps has registered themselves, perhaps is saving. At the end of the day, he will get a house and you will not get one.
And somebody can also, instead of going for the propaganda, somebody can actually go to the Boma Yangu and
you
get
can
all that.
go online to your eCitizen account, go under the National Housing, the Ministry of Lands and Housing. You will be able to see an app there about Boma Yangu. Get in, see what is there. Before you are lied to by other people who do not know what is going on, go inside that portal, see what is there. If you can't access it in your phone, go to a cyber cafe somewhere. Ask that person on cyber to help you see Boma Yangu. then you can come out with informed decisions. Otherwise, we are being sold to propaganda. At the end of the day, if those houses remain empty, it's because of our own ignorance. If those houses get the owners, because at the end of the day, kila ndege lazima ajivunie. Huwezi kungoja utafutiwe mdudu ndio uletewe. You are not, wewe si kinda bwana. Wewe ni binadamu, uko hapa Nairobi, uko wherever you are. Go to boma yangu first. Information is power.
All right.
Yes.
And Doc, picking from where Ngoni has left, the boma yangu and the affordable housing project is something that has been admired and also condemned in equal measure.
Yeah.
And I'm talking about condemnation because we have a case in court challenging it.
Yeah.
But looking at the theme of the day on Mashujaa Day, the president did indeed mention that not only is it going to, this is a project that's going to be giving a lot of Kenyans who are homeless homes, and even Kenyans who, like us, who can be able to purchase a house. He mentioned something about the jobs.
Yeah.
And let's be very honest, these houses are being built by our very own.
Yeah.
They're not being built by companies from outside. I would like you to weigh in on that as well.
Thank you, Ben, for the invite. And let me start by wishing all our candidates all the best in the upcoming exams. And to come to your question about boma yangu, I have a different view. And let me ask in Kiswahili, nani anataka nyumba? Ni swali langu tu, nani anataka nyumba? My brother here say that many people in Mukuru, Kwanjenga, Orogosho, they need houses. He went further to say that you need to go to the cyber and check on boma yangu. Can those people in Mukuru, Kwanjenga go to the cyber? What is the need of those people in Mukuru, Kwanjenga? Is it the house or food? It is food. Housing is good, but unajengea nani? Who has complained that he need a house? The president talked about, he's talking 90% about housing, bringing in the jobs. So his talk is about creating jobs, not providing housing. 90% of the speech of the president is creation of jobs. Ben, you have said clearly that people who are building these houses are locals. It is true. But what about the gender issue? Are women building these houses?
I've seen them.
The president talked about yesterday.
We have seen, we've even interviewed some who have been working on these projects as well.
But which percentage? 1%. 99% are men. So are you creating jobs for men? What about the women? Yeah, you can say wanatengeneza githeri na uji wanapeleka kwa site. But after that, whose house is this? Us in the employment sector, we are being deducted money. Even you. Are you assured that you are going to get a house? The president during Mashujaa Day talked about savings. Talked about Jemima Kwamboka. He has saved some money. Talked about some guys, a disability guy, person living with disability, saving. So you are saving so that you can buy a house. We are being deducted so that we build houses for other people. So whose house is this? Hii pesa yenye tunakatwa ili nyumba ijengwe, itakuwa yangu? Itakuwa yako? Nitapata aje nyumba? Those are some of the questions that the petitioners in court are asking themselves. In fact, the Uhuru Kenyatta model was better. You could see how you will get the house. But for this one, I don't see. Mm-hmm. I don't see how you are going to get
I
the
believe
house yourself.
from the petition that was filed in court, they are actually challenging a number of things, because actually what you said is contained in the petition exactly.
Yeah.
How am I going to get, and how can I even access all these people in Mukuru, in Kayava, who can be able to access the internet and follow the prompt and actually save for their house and get the house?
Yes.
Those are some of the questions that I'm quite sure that the legal minds in the High Court are going to be having. I actually don't envy them, because it's doomed if you do, doomed if you don't, because actually the project has already hit the ground.
Yeah.
Yeah.
But Ben Troy, I think Daktari is trying to be cagey and corny in how he is handling it. The basic human needs are food, shelter, and clothing. Food, shelter, and clothing. The government has decided to tackle food by empowering farmers through the subsidized fertilizer. Remember, we used to buy fertilizer at 7,000. If you go to commercial retailers of fertilizer, they are now selling at 7,000. But the one sold by government is 2,500. The other day, there was a tea cooperative that wanted to raise that amount to 3,250. But the president, in his speech during Mashujaa Day, reiterated and said the fertilizer will continue retailing at 2,500. That was an order under directive. Otherwise, if there is anybody who is thinking of selling that, should go the commercial way. But what the government is giving and government agencies must be 2,500. The government is handling the food part. The government cannot come here feeding us. The government cannot go around, but the county governments are trying to feed the children through the school feeding program. But at the end of the day, there is an issue with shelter. Yes, you may not need the house, but your son needs a house when he comes to college in Nairobi. Will you continue renting? Will you continue? You need a house. Yes. Instead of going to the commercialized houses that are out there, which are actually expensive, yes, outrightly expensive, 18 million, 20 million, 100 million, who will raise that to 20 million? The most expensive house I am seeing, a 3-bedroom most expensive house, is 2.5 million in the government affordable housing. Affordable housing is not for those slum dwellers alone. They are city dwellers who have been paying rent. There was a time I was calculating a rent of 20,000, yes, per month, multiplied by 12. Already you have paid a landlord 240,000. Times the years you spend in that city. For example, let's say you work for 25 years. How much would you have paid the landlord? Over 3, 4, 5 million. The government is just saying, practically, you would have owned a house in the city. It's not forcing anyone. But it is saying, and let us help these ones to pay. Because we are a country. We are one unified nation called Kenya. Your problem is my problem. We can't ignore, because we have a job. We are privileged that the few buying sugar, the few buying salt, the few buying matchsticks, and the 16% VAT going goes into Daktari's salary, and that salary, Daktari ataki guzwe ni yake. Yet it comes from the local man. That man running a posho mill is paying taxes. That man who is even, we pay taxes, even when you go shopping in a supermarket. At the end of the day, you get a receipt, VAT hapa chini. So umelipa salary ya Daktari. Daktari hataki salary yake iguzwe. I went to school, I studied, I became a doctor, I'm earning 200,000. Nobody should touch my money.
All right, let's hear from Daktari, because
it has the money has the roots where it came from, and it should go back to help the community.
And it's also good to mention that this program is not just being tried out here in Kenya. It's something that has been tried before. And maybe we would like to hear some of the benefits that will come from the housing project in your view, because indeed you have challenged a number of things, including the information, including who really need these houses. And you said indeed that is why we have raised some substantial questions in court, and we need some deliberations by the court. Tell us.
Thank you. Before I go there, let me ask Mr. Meli. I don't challenge the affordable housing, but tell me, how am I going to get the house? ask yourself, how are you going to get the house? That is the question that I'm asking. How are you going to get it? Now,
away from the information, away from
anyway,
because there is some,
yes.
but I totally concur that in terms of information, because
Yes.
not all Kenyans can be able to log in and go to
It is
Bomayangu
true.
and follow the prompts
Yes.
and save money and access a house. These are some of the issues that, let's call them teething problems.
Yes.
These are some of the things that we can overcome. Would
Yeah.
this still be viable according to your view, Dr.?
If it can be arranged in such a way that the future can be seen, it can be good. It can be a good thing for all of us. If it can be arranged in such a way that I know at the end of 10 years, I'll get a house in, say, Nakuru, say, Kericho, say, Eldoret, okay? If the roadmap is very feasible, and then I have no problem. But the future is not feasible.
All right, because
is not
we also waiting for for that. Still on this speech,
Yeah.
The head of state didn't mention anything in regards to the impeachment. But if you read between the lines, he did talk about national unity and also told us as Kenyans that
Yeah.
we also need to pull together, not because of the regions that we come from.
Yeah.
I would like to pick your mind in regards to that.
Thank you so much. The speech from the president did touch on the impeachment indirectly.
Yes.
He talked about Mekatilili Wamenza being a nationalist, that Mekatilili fought for Kenyans, not the community. So he was touching on Rigathi Gachagua indirectly, to my view. Him being silent is very loud on the same. And I can say that his hand is in it. And if you can see his soldiers, they are working day and night. So the president knows a lot of things about the impeachment, and there are many things that we are not told behind the scenes. And if you hear what the impeached deputy president talked about when he was discharged from current, he talked about these things starting 1 year ago. So meaning that their relationship has not been good for the last 1 year. And to me, it will be messy, and it will be very noisy. Going forward, the way the impeachment was carried out, it was hurried. If there is a problem, the law talks about 14 days. It talked about 60 days in parliament. But if you can see, it did not even last for 1 day. And you could see from afar when the parliament impeached him, and they set a date for Friday, a special sitting on Friday. And then whatever was in the Senate, and they knew that by Thursday evening they will impeach the deputy president. They'll remove him in the Senate, and then on Friday they will receive the name, and they will forward the name to the president. They will receive the name from the president, and they will finish everything. So they knew very well. So this thing was planned, okay? But to me, the best was that the president should reconcile with his deputy and just move this country with other things, like economy, like the other things, like even this affordable housing, okay? Instead of these things. Remember, Uhuru Kenyatta and William Ruto, they did not work together in the last 5 years, 2018, 2022. But Uhuru Kenyatta did nothing to him. But look at the president and the deputy president, and they are Christian. Their wives are powerful Christians. the other one is a pastor, and the other one is a prayer warrior. What are we showing Kenyans? Which heaven are we going?
Okay.
You see.
Okay. I totally understand this whole issue is so quite emotive, and even the church did weigh in, I think, on Sunday. But Melly, picking from what Doc has talked about, in as much as even couples, it was from what the impeached deputy president said that this issue started a year ago. So it's safe to say that the marriage was rosy only for a year. And there are other alternatives that are there, including mediation. I would like to pick your mind in regards to how this whole process was carried out.
I think first, by the president steering away from this discussion, he is obeying the fourth law of power, the 48 laws of power that say, always say less than is necessary.
But to be very honest,
always say less than is necessary.
But Melly, remember, he is the head of state. We are talking about his principal assistant, as enshrined in the Constitution. And Kenyans, because we voted for them, we should have been taken through to know that indeed the marriage is on the rocks, and this is where we are now. If it's a mediation from both sides, remember, just as Doc has talked about, the marriage for the president back then, Uhuru, and the president when he was deputy president, was not rosy for almost 5 years.
Now, I think one thing the president is trying to do is to avoid being appearing like he's interfering with the other arms of government. Remember, he's a symbol of national unity, and there's judiciary on this side, there's legislature on this side, and he's heading the executive, which is also like the umbrella of the entire the nation.
You're talking about the principle of separation of power.
Yes, the principle of separation of power. But you see, always speak, but sometimes silence is golden. But for
I'll
him,
still pick you on that, because just a minute, you're saying that the principle of separation of powers, indeed the parliament, the two houses did their job, and we are waiting now on the judiciary, and we have the executive. Are you saying that he did not have a hand in that?
Now, you know, there are some things you cannot contemplate that will happen. For example, your deputy has already been impeached. You don't have a deputy. You must pick one to safeguard the nation, because there will be a constitutional crisis if one is not picked. First, I want to agree with Daktari that this process was rushed. From the observation of things, but if you look at the days that the processes, the parliament staying up to midnight, the next day again almost going up to midnight, then after the conclusion of the event, remember Parliament and the government printers is just across the road. I would imagine you are finished with the business, everything is on the table. What do you want? The next thing is to tell the messenger, take this for a gazette notice across the road. And even the Senate is just within the same compound. So, and perhaps Senate had already briefed the senators that there would be an issue coming from the National Assembly. So let's stay alert. If it would have failed in the National Assembly, then the Senate would not have met. But if it, since it went through, you see, there is usually a communique that is sent out to the senators. Don't go out of Nairobi. There's an issue we want to discuss this day. If there is no issue, they are always also told that there is no issue. Now you can proceed on your personal things. And since the Senate was the jury, actually, where I saw unfairness in the Senate is even in the courts of law. If a victim or the person who has been brought before the court falls sick, you always see a judge saying, we suspend these hearings. I want this person to get medical attention. We will resume on a certain day. And Parliament has powers. They could even come up with a vote to extend the sittings to a certain day. Remember the words of our national anthem. Justice be our shield and defender. I want by the time, for example, Rigathi goes home, he has seen justice has been done. there should be no shortcuts. The president can sit pretty and wait until all these processes are executed. Even if the courts were to suspend and say, put aside the impeachment, there is enough time to come up with another one. If the processes were not followed, if the charges are justified, there is enough time. We are not in a hurry. It's not like Kenya wanahama tunaenda kwingine. We are here to stay. And if we are here to stay, let's give each other time. A marriage sometimes you can take a divorce case to court. But the court drags the case to see a way in which you can come together. You remember there is even some bishops who went to State House to unify the two. I'm told, I read a newspaper yesterday, a headline that was screaming that these people went there and they had the recording, another recording that we don't know, that incriminates the deputy. Then we said, if that was then why all these other charges? Why these other 11? Bring that one. And I say, in politics, what is said is not politics. What is not said is now the politics. There is something that Rigathi did that is not among these 11. Perhaps there is something.
Since we are having a constitutional moment now, and I'm quite sure, Doc, you will really acknowledge this, in 2017, after the elections, I think that is when we really tested the pillars of our constitution the most, when the Supreme Court annulled the presidential election and ordered for a fresh one. And this is the second time that we are really testing the foundation of our constitution in regards to the processes that are leading up to the impeachment. But looking at the effectiveness of, let's first of all go to the National Assembly, the effectiveness and the quickness that the matter was handled in court. The following day, he was impeached on Tuesday. Almost the whole house was there. But on Wednesday, we couldn't even find a quorum.
A quorum, yes.
If indeed we are putting, we are testing our constitution, which is very robust, and it's a very good thing that we are testing it. Just like Meli has mentioned, it should have taken the constitutional time that, or the frame, the time frame that is there. 60 plus 14 days brings a total of 74 days. But it was done in what, less than 12 hours?
Yes.
We were done. Thank you, Ben. In this country, to my view, we don't have 3 arms of government. We have 2. That is one, judiciary, and the second one is executive and parliament. They are together. To me, we have only 2 arms of government, judiciary, and then let's say executive. Executive, parliament is inside and senate.
Can you say execute parliament?
Yes, I think that one can.
Yes.
So we have only 2. And that is why, to me, there were a lot of instruction from the executive that can you finish this matter within a specified time? And that is why they hurried. A process of 74 days, 2 months and a half, will take around 6 hours, and you are done. And the name is there. The president was ready with the name. He did not even wait for parliament. He did not even wait for communication from the Senate. The following day, there was a name. And Uhuru Garden, they were ready for what we call swearing in, save for the orders from the court. So you can see, and you can qualify what I'm saying. There are only 2 arms of government. So our savior here is the judiciary. The judiciary, to me, 80% independent. 80% independent. So that is an A in the university. But Parliament and Senate, those guys are compromised. They are just waiting for orders. Listen to Amason Kingi saying, give me 5 minutes. And he went to his office for 30 minutes. What is he doing in this office? Waiting for instructions. Do like this, do like this. And then the senators are told, can you finish that matter? Amason Kingi comes and say, I have no powers. It is you, the senators, to decide. We've postponed it to Saturday, and then we finish that matter to give a chance to the Deputy President, Rigathi Gachagua. And all of them, they voted that we are finishing this matter, and they finished. My friend, we have two arms of government. We are waiting for the court, and if you can see, Rigathi Gachagua will get some justice in court. Mm-hmm. Look at Mutuse, the performance. To me, that guy got an E. An E. A petitioner who cannot even answer questions. He did poorly. And you want to say that petition sailed in the parliament and sailed in the Senate, and the petitioner could not substantiate some of the allegation? Ben, even if it is you. So the court will give us a true meaning of justice. Mm. That is what I can say.
Yeah, Sammy, we are looking at, from what Doc is talking about, indeed, everywhere people are talking about the two houses being compromised. And this is something that we have seen even in previous governments, where the government agenda always takes a center stage. If indeed we are testing the tenets of our constitution, this is watering down that. If at all, the executive will always have power over the parliament.
Now, where we fail as a country is having the president as the leader of a political party, at the same time wielding a lot of financial power. You see, for example, the NGCDF comes from the national government. It is not constitutional, as a matter of fact. Mm. So perhaps if you look at the members of parliament who are towing the government side, there is development going on in their counties or in their constituencies. But these other rebellious members of parliament, nothing is going on. Perhaps that is the thing that has caught our parliament. Parliament should deem itself from being the puppets of executive. Parliament having two houses, I saw the Senate was a little bit mature in how they handle their issues. In how even they debate, you would see some maturity in the Senate. But I want to decipher some issues where Dr. Aria said, you can't defend. Remember, when drafting a bill, there are legal minds in Parliament who are employed to assist you as a member of Parliament to draft a bill, to come up with a motion, and sometimes you don't get enough time to be acquainted with what you have on the table. Mm-hmm. There are quite a number of lawyers that are employed in Parliament. And in drafting, this was a bill, this was a motion drafted for this member. Mutuse, his problem is that he didn't sit down to study his motion and get facts from every page. Sometimes he would even want somebody to help him open a page. And that was a failure on my side. But remember, we have sent members of parliament, and there is no serious qualification for you to be a member of parliament in this republic. No serious qualification. So even class 8 dropouts, whom, quote unquote, have issues with their papers, can come with a bill. And that is why they usually want somebody to second them, some other members of parliament to assist in explaining all these things. But crucifying Mutuse did his constitutional duty as a member of parliament. He has to check on the national government. Let us not be motive and angry with him. He was exercising his constitutional rights. If I realize that you are wrong, Trevor, I can take a case to court, and it is in the jury or at the court that will be able to explain ourselves. And in the minds of the jury, what they get from you is how they will vote or how they will give a ruling. Senate gave a ruling depending on what they had on paper. It was not all, every senator had a booklet of that charge, of that motion. So some read for themselves, some had the lawyers explaining them, some had Mutuse explaining it, and they could go through. There are things that we didn't see ourselves. Some were being even showcased on screen. For example, did you see even a single CR12 yourself? Do you have a copy of it?
No.
You had it, and some were shown on screen. The others which were not shown. So the members of parliament and the senators had the benefit of the documentation. Some of us did not, we just listened to what the media said or what was being aired live. There is a lot that we didn't read in that document. So perhaps that is how the judgment was made. But otherwise, the rush in doing things in this country has shown us we have a competent parliament that can deal with our issues if they are serious. But sometimes they don't take our issues seriously. They take others' issues seriously, especially when there's an M-Pesa going on or those toilet stories. This time I didn't hear. Perhaps they were disciplined, they ate with discipline. But I am sure that the deputy president deserves justice. He should be given enough time. We have even up to July 2027, before even elections, that these things can be determined and concluded. Otherwise, he should explore all relevant arms of government that can assist him get justice. Otherwise, we should not lynch him, and neither should we lynch the motion mover. He was exercising his constitutional rights.
All right. As he exercises his constitutional right, we have some ripple effect, of which, gentlemen, I want us to look at when we come back. We're going to be having a lot of intense and immense repercussions in regards to that political move. We are waiting for the judicial process itself, which we will be crossing over to Parliament, to the Milimani law courts to know exactly the political implications. Why I'm saying this is because we do remember when we had issues with President Uhuru and his deputy, who is the president now, President William Ruto. There are political implications in regards to that. So, gentlemen, prepare for that. You're indeed watching KBC News Check. Let's take a quick break. We'll be right back. But just to remind you, as soon as the impeached DP petitions begin at the Milimani law courts, we'll be crossing over for a listen in. Let's take a quick break.
Are you a holder of unclaimed financial assets? All holders are notified to report and surrender unclaimed financial assets to the Unclaimed Financial Assets Authority, UFAA, on or before November 1st, 2024. UFAA. Receive, safeguard, reunite.
Nyinyi ndio mnaotuongoza. Ni kweli mmemchagua Mbura awe kiongozi wetu?
Mwanamke sio mtu wa kuamini. Anaweza kukua wakati wowote akitaka.
Sio kwa mke wangu.
Kwa nini wanaume waone thamani ya mwanamke katika jamii? Ni kwa sababu ya mila na tamaduni zetu, ama ni ubinafsi tu wanaume wako nao?
Mimi ndimi kiongozi wa wafanyakazi wote pale kwenye serikali ya Mbura.
Huo uhuni wako hautoshi hata ukucha wa kidole cha mguu wangu.
Tubaki hapa peke yangu, twende sote.
Thank you for joining us on Healthy Living. Stay connected to Voice of America at voanews.com. A look at your kidneys and how they impact your health. And an expert discusses chronic kidney disease and how to protect yourself. And Ivorian psychologist Noor Bakayoko shares some insights on bullying and what can be done.
It's important to avoid major events or major health crises.
How do you know if your cough is due to a serious condition? We'll have some answers. Stay well
and strive to make every day a healthy day.
Welcome to Kenya, my guy, and most importantly to this school.
Thank you, bro. Yo, what up, Africa? What it do, what it does, what it done, what it did. It's your boy. Super producers.
Can we get on with the lesson, please?
My name is Jules with a Z, but you can call me Juju.
Wacha upumbavu. Julia, you are Julia. In fact, Mr. Man, call her Julia.
Solendan, Mashambiki.
I mean, they got the voice, but look at her. She got the looks, bruh. And the video is all about visuals, bruh. Visuals.
Welcome back to KBC News Check, and thank you so much indeed for keeping us company. We are looking at the state of the nation, and in this regards, of course, it's something that is on everyone's lips is the impeached DP petitions that are currently awaiting to be heard at the Milimani Law Courts. That's not only the thing that we are following up, we're also following up on the KCSE, which begins today. We're also following up on the affordable housing judgment, which is supposed to be the Milimani Law Courts as well. And also, we also have the COP29 that is currently in Colombia. Those are some of the things that we are keeping tabs with. In case you just joined us, I'm in the company of Sami Meli, and just next to him we have Benjamin Koskei, Dr. Benjamin Koskei, who is a senior lecturer at the Kenyatta University. Well, before then, we were looking at the impeachment of the Deputy President, that is Rigathi Gachagua, and we are waiting for the live link from the Milimani Law Courts, where we'll be crossing over to just hear some of these petitions. They're numbering about 30 now as we speak, up from about 23 last week. Gentlemen, before we took that break, I was mentioning that in regards to what has just happened in the impeachment of the Deputy President, going to have a lot of ripple effects. Some are going to be intense in regards to the political formations. As a political analyst, how do you see it? Because that is the same thing that happened before 2022 general elections. The two principles had differed, and that is where the political alignment and formations came about. Are we likely to see the same thing?
Oh, yes. We will see a lot of political realignment. Number one, if
just a minute, Doc. Those are live pictures from the Milimani Law Courts, and as you can see, the impeached Deputy President Rigathi Gachagua is seated in the company. I can spot 2 or 3 lawyers there, and the court is quite full. We'll be crossing over to Milimani Law Courts any moment now, as soon as this petition begins. But currently, we are here in studio and waiting for for the judges at the Milimani Law Courts.
Thank you so much. I can see Rigathi is now well, and I wish him all the best. And number 2, there will be a lot of realignment. If Rigathi will be sent home, number 1, he will form his own party, and he will canvanize the Kikuyu vote in totality.
That is if the courts clear him, because if they don't clear him, that it is not viable to vie for any political
In any case, he will form his political party.
Either way.
Either way. Number 2, William Ruto will go to Nyanza and Western, and then Mount Kenya East, that is the Meru, and the Rift Valley, that is the Kalenjin votes, and Coast. And if Raila loses the AU post, it will be messy and noisy, because Raila will feel shortchanged. And Raila, to me, that is a person that you cannot trust in politics. To me, I don't know, to Meli. Raila can jump, and even he can go to Rigachi's side in the next election. And that is the real politician. He is a real survivor in this country, and he has survived all through, and he knows how to do that. So, Rigathi right now, where he is, but if he is not impeached, He will silently form his own party, and his constituency will not trust again William Ruto. Take it to the bank. Either way, he will not trust.
Still on the same, Doc.
Yeah.
As we have said, is that what we don't hear and what we don't see is where the politics truly lie.
It is true.
And I remember him in one of the televised interviews, he said that because he was so trusting, Mount Kenya as a region or as a voting bloc did not come on the table with an agreement or conditions or anything, whereas we see the likes of Speaker of the National Assembly, Dr. Moses Masika Wetangula, we've seen the likes of the Prime Cabinet Secretary, Musalia Mudavadi, we've seen the likes of PAR leader, who is the Speaker of the Senate. From what the DP said, and from the documents that he presented to court, is that these people had an agreement, including Mutua of the Maendeleo Chap, which actually sponsored the bill, the impeachment motion. Was it the undoing of the Mount Kenya region to not enter into that agreement in a political outfit? Remember, during the TNA, Uhuru had TNA, and the president, who was the deputy president back then, had URP.
It is true.
Was it the Mount Kenya region undoing?
To me, it was not undoing, because you remember during 2022, we had another party in Mount Kenya. That is for Uhuru Kenyatta, Jubilee Party.
And you also had the likes of Kionjuri as well.
Yes,
and even
you
Moses
can see.
And Moses
and even
Kuria.
Moses Kuria. And even Waria. Okay? And even Kabogo. So Rigathi saw that if I have another party, it will not have a lot of effect. So he joined hands with Ruto in the fate of Jubilee, the Jubilee of 2017. Okay? But he didn't foresee this thing coming. He didn't see that this is coming because of the faith, the Christian faith. You know faith, you don't reason. Okay? You just trust in God, that there is God in heaven. You don't reason. So Gachagua with Pastor Dorcas trusted Rachel and Ruto, the Christian faith, and say we are going to this war. And at the end of it, we will reach the mountain, and eventually we will be in heaven. But now look at this. He didn't foresee this. But going forward, he will form his own political party. And by the way, right now, Rigathi ako juu sana. Right now, where he is right now. In fact, let me tell you, if election comes in November, him and Ruto, he will beat Ruto. Right now. That is my analysis.
Meli, let's go back to the truthful man again. He said there is a truthful man, and on Sunday he mentioned that some of the reason that they were at loggerheads with his boss is because he brought about Adani, he brought about the affordable housing, which is also being challenged in court. But let's go to the truthfulness and honesty. When he was deputy president, Rigathi Gachagua did drum up support for the affordable housing, only now to come and castigate it. He talked about tapping in foreign investors, Adani being one of them. He's bringing up all those issues now. Is he really being truthful and honest?
Now, one thing, what I was thinking about all this scenario that we are seeing, there is too much going on in this country, and perhaps this is a decoy. The Rigathi issue could be a decoy that is diverting our attention from the Adani issues, diverting our attention from Shif and Shah. I heard somebody calling it Shisha. They are diverting our attention to the housing, from the housing issues that we had, and perhaps this will take some time, some sweet time of our attention, such that at the end of the day, things would have moved under the carpet. But the truthful man branded himself. He used to say things, and we believe him. Even up to the other day, when he was speaking, he came through a press conference before he appeared in the National Assembly. he said quite a number of things that, quote unquote, ended up putting him in trouble. And I said before, always say less than is necessary. By being truthful, he was trying to win the hearts of Kenyans more than his boss was doing. And perhaps he was trying to outshine the master, and the master realized in good time that this guy, if I'm not careful, will take over my government. The truth we have, but when you hear what was happening in the National Assembly, some were truths and some were half-truths and some were exceedingly outright lies. And therefore, his truthfulness is still in question, but he had won their hearts. The crying of the deputy president's wife, Madam Pastor Dorcas Rigathi, crying before the camera, whipped our emotions. Even those who had hard hearts changed, because nobody has ever seen anywhere above the ruling class crying. And that is when I learned one thing: the rich also cry. The only cries I saw that were from that class is when President William Ruto did not believe that he was the deputy president. He couldn't believe that he would be sitting on a deputy president's chair in a place he used to go and book appointment. That was the last cry I saw. So this crying whipped our emotions. It has brought back sense to some of us who had very hard hearts and were unforgiving. But all this was I could see things like this coming from Rigathi's speeches all through. Sometimes even somebody would ask, why did he have to say that before the president? In fact, even guiding the president before the multitude. And you would see, if you see William doing this and smiling, my friend, you have hurt his heart. He is not smiling. And these things were planned, they were there, and he knew that it was coming. That is why he was even more bold towards the impeachment season. He was bolder and even courageous to handle some issues. The issue of Gen Z, when he addressed us in Mombasa, one thing was, why was he addressing us from Mombasa when the president was addressing us from State House, Nairobi? It reminded me of a movie, The Designated Survivor. He was playing the designated survivor, that in case things happen here, I take over from Mombasa. And perhaps that also anchored his boss. And you know, for those people who are close to William Ruto, will tell you that once William Ruto starts ignoring you, know that he never tells you that he has a problem with you. He just starts ignoring you. Know that you are in his wrong books. And if we are not careful, we'll go back to my first statement. This is a decoy. Something is going on in this country. Once we wake up, we will have Adani International Airport. Kenya Power will be Adani Power and Lighting Company Limited, because there are some things perhaps Rigathi was against. At the end of the day, why would you sell our heritage? Why would you privatize our heritage?
For 30 years.
For 30 years. Hata ingekuwa 10 years. At 5. Actually, by 2032, if he's living, we would have somebody else to take over from that. But giving somebody, imagine Troy, at this time, let me assume you are 39. In 30 years, you'll be 69.
Actually, in the next 30 years, I'll be in my 40s. In my 70s.
Yeah, you'll be actually 70. Toko una sign in kwa pesa ya wazee. 30 years is a lot of time to give out a national heritage like that.
All right. Since somebody can argue that that has not been put into pen and paper yet, I will still pose the same question I posed to Doc in regards to how do you see the political formations coming up. But before you answer that, allow me to remind our viewers that those are live pictures from the Milimani Law Courts, and as I can see, the court is quite full. We're expecting the petitions in regards to the impeachment of impeached Deputy President Rigathi Gachagua will be heard by a 3-judge bench. I can see the likes of lawyers Kibe Mungai, I can see lawyer Gachagua'S, I can see the former UDA SecGen Cleophas Malala, I can see the brilliant lawyer Ongoya, we can even see the Kiambu woman representative, the likes of lawyer Danstan Omari, I can see also Gachagua'S, also a brilliant lawyer, and also some politicians here and there. I've seen the likes of Dan Manzo, who is a senator, and we are waiting for that case to be heard and determined. So as soon as the judges do get into that law court, we will be crossing over. So back to you, Meli. What do you think are the political ramifications of such a move in regards to the DP? We've saw 2017, a lot of new alignments.
Now, we had a disclaimer from the word go. Musiguse Murema. And the truthful man was saying that. That mountain has been shaken. That mountain, the volcano and the magma that is bubbling in that mountain, I don't know what we will need an atomic bomb to take it back. First, things first. William should come out, President William Ruto should come out and unite the country. Assure us that the processes going on are constitutional processes, calm down the country, and at the end of the day, I don't know what he will have to do to bring back the mountain that he was told not to touch. That mountain is slowly shifting. Seismic activity down on the tectonic plates of the mountain are actually rumbling and shifting. We might have a serious rift that he will have to build a serious bridge to go back to the mountain. Otherwise, if that doesn't happen, or if this happens and Rigathi goes home, the mountain has gone home with him. The mountain will be looking at Rigathi to give it direction. Where next? What President William Ruto should do right now, if that happens, put all his resources, human and supernatural, on the presidents of Africa to vote in Honorable Raila Odinga to be the AU chairman. Then he will bring the lake, which he will use the water of the lake to calm the mountain. Otherwise, this mountain, the volcanic eruption that is there, has never been had in the history of this world. These people are united. I have never seen a people united like the people of the mountain.
All right, and still on the same, let's be very honest. Since the finance bill, the ground has been hostile.
Yeah.
True or false?
True.
In either way, whether the DP was impeached or not, the ground was still hostile because of the finance bill. And of course, a number of Kenyans have mentioned, you told us there's a hustler government, you told us Mama Boga, you told us there's that hostility on the ground. And they say vitu kwa ground is different. Now, this is something else that has come, of which, like you said, the tectonic plates are rumbling. Where does this leave Kenyans as well? We also have to remember that Kenyans were not quite happy.
Now, the Kenyans should understand one thing, is that mwanasiasa si mwenzako. A politician is not your fellow, your peer, because these people can unite on issues that are bedeviling them and ignore you. Let's not whip our emotions and follow the politicians' directions. We should be sober. Remember that this country is one united country called Kenya. We are Kenyans. Since President William Ruto took over, not even a single plate increased in my home. The size of ugali that we cook is still the same. The sugar that we put in our tea has always remained 2 spoonfuls per cup. It has never changed. And that is why what we should and look at is not where the president comes from. Because Bwana Kosgei here can tell you, Daktari, that where he comes home, from, in fact, perhaps the roads are even worse than they were before. What I am looking forward to is even having a Giriama president, a Ribef president, a Somali president, a Taita president, a Luya president, but somebody who works. We should look forward to a day when Kenyans will have a clear objectives on their election of who to rule them or who will lead them. Otherwise, Kenya is a unified country. We should not whip emotions into what is affecting politicians, because at the end of the day, when you sleep angry, he doesn't send you tea, he doesn't send you soap to wash your clothes, but what we want from politicians is to give us development. I want, when I leave my home, I have a good road, I have affordable fuel, I have, I can live securely. I don't need security. Because what even the deputy president, impeached deputy president was trying to send a message is, we are insecure in this country. That is why he needed security. From who? From us. He feared us. He fears us. That is why he cries for security. And I am wondering, look at when the president was in the US, he was crossing the streets. I could see him crossing the streets of New York. There's even a small girl who bumped into him and he pushed her aside. Even the security were not there. I'm looking forward to a day we shop here at Quickmart with the president. Namuona anashika nini na mimi niko na yangu.
And our governors wakipanda basi,
and the
just like they do in Europe.
Buses.
Yeah. And since, from what I've seen is that the court is almost in session. Okay. Let's go back to something you mentioned, and it's something that has come up not only this year. Yeah. Some people have claimed that Parliament is an extension of the executive. Let's look at the MPs.
Yeah.
After the finance bill, Kenyans were very hostile, and actually some were chased away, and some had to wear T-shirts saying "Forgive us." But let's be very honest: the leaders that we have is a true reflection of who we are. You remember the finance bill? Yeah. They voted yes, despite Kenyans saying no. Yeah. And then the president comes out, flanked by the MPs, and said that, indeed, that's it. We're not going to go on with the finance bill. How do we ensure that Parliament is not an extension of the executive? But unfortunately, my director, Mugo Kariuki, said, informs me that we have to go to Milimani Law Courts. Sami Meli, a governance expert, just next to him. We have the Dr. Benjamin Koskei, lecturer at the Kenyatta University, and also a political analyst. Thank you so much, Injil, for joining us. Let's cross over to Milimani Law Courts and follow up on the impeached DP petition.
I'm Dorcas Udura, Attorney General, Senior Counsel. The Attorney General has also been sued as a party, and therefore representing the Attorney General is Professor Gidi Mwigai, Senior Counsel. Shadrach Mose, the Solicitor General. Emmanuel Bita, Deputy Chief State Counsel.
Emmanuel who?
Emmanuel Bita.
Where is he? I'm present,
He's been swamped. And Chance Mutinda, Deputy State Counsel.
Present, my lord. Present.
For the National Assembly, we have Eric Gumbo.
I'm present, my lord.
Paul Nyamodi.
Present, my lord.
And George Murugara.
Present, my lord.
For the Speaker of the National Assembly, we have Benson Milimo, Josephat Kuyoni. Oh, sorry?
You introduced Mr. Murugara for?
Mr. Murugara George for National Assembly. For the Speaker of the National Assembly, we have Benson Milimo, Josephat Kuyoni.
My lord, I'm present. Just back who?
Kuyoni. Kuyoni. For the Senate, we have Professor Ojenda Tom, Senior Counsel.
Present.
Moni Mukele Edwin.
I'm present, madam.
And Senator Hilary Sigay.
Moni who?
Moni Mukele Edwin.
And Professor?
And Senator Hilary Sigay. That is for the Senate. For the Speaker of the Senate, we have Mercy Tanji. And Peter Wanyama.
I'm present.
For Professor Kindiki, yes, and DP nominee, we have Mudomi Kiankolu.
I'm present, my lord.
Moses Kipkosgei and Ken Meli.
Present.
My lords, your leadership, in petition 565 of 2024, may I, at the very outset, before I state counsel appearing as the Deputy President applicant, may I, at the very outset, say that I am stating the quorum under protest. We are not willingly here participating, and we will elaborate. But let the record show that counsel appearing for the Deputy President today before this honorable court appear under protest. As I say, the basis will be elaborated later. I appear waited for the record. I appear with my colleagues, Tom Acharya, Elisha Ongoya, Faith Waigua, Victor Soanya, Debo Wanjiru, Andrew Muge.
This we are recording the quorum. Faith
Waigua, Victor Soanya Ogeto, Debo Wanjiru, Andrew Muge, George Wandati, Mr. Sakin Pa, and John Joe.
Present, Lord.
My lords, your leadership, as I sit down, I seek clarity on whether it is only petition 565 of 2024 that this honorable court has before it today, or whether there are any other petitions. I thank you.
So we take quorum on all the files that are before the court first.
Petition E015 of 2024 at Kerugoya. Petitioner David Muni Mazenge and 4 others versus the National Assembly and 5 others.
May it please your lordships and my lady judge, in E015 of 2024, the quorum for the response is the same, save for His Excellency the President, who has been sued in person and is being represented by Adrian Kamodo.
Just for the purposes of clarity, just will record the quorum fully.
Dorcas Odur appears as the Attorney General. For the Attorney General is Professor Igai, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Bita, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel. For His Excellency the President, Adrian Kamodo. For Professor Kindiki, is an interest case. Mudomi Piankolu, Moses Kipkogei, and Ken Miller.
Your Lordships and Your Lordship, my name is Kibe Mongai, appearing in this matter with the following. My Lord, in this matter, I appear with Senator Daniel Manzo.
Listen, my lord.
Your name, please. My name is Kibe Mungai. I thought I'd said it, my lord. Kibe Mungai. Sorry about that. I appear in this matter, my lord, with Senator
continue behaving like this, I won't go back in the car.
All right, if you don't get in, how will you leave? See you later.
Iker! No, Iker! Live in my house. I won't allow you to get me into more trouble than I have.
This is also my house, right? How many times will you favor him over me? What else do I have to do for me to be chosen?
I thought that Sergio was going to ask me to marry him. And he didn't say anything, no, nothing at all.
And the 2 times she was with Danielle, they ended up in the hospital.
What did you say, Mother?
Arturo, what's wrong? What is the matter?
Wild lands.
That continues to be referred as Kerugoya, petition number E015 of 2024 that appeared to have been filed on the same day.
So you appear for which party?
We appear for the petitioners in that matter.
Appear for the first interested party, that is the Deputy President of the Republic of Kenya in this E015. The Lords, again, let the record capture and show the council appearing for the first interested party appear under protest. Council are as follows: Paul Mwite, Tom Acharia, Elisha Ongoya, Faith Waigua, Victor Soanya, George Wadati, and John.
Can we have that again?
Yes, I'm sorry. From what point, my lord?
From yourself.
Paul Mwite, Tom Macharia, Elisha Ongoya, Faith Waigua, Victor Soanya Ogeto, George Wandati, and John Job. At the appropriate time, we will be going into the grounds and basis for appearing under protest.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given. My Lord,
before Mr. Kibe moves on that file, there are other files, especially file number petition E572 2024. Sit before the bench.
We'll take quorums on the files which are before the court and that you can raise any issue.
My lords, may you kindly equally confirm whether E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimozo Maingi, petitioner versus Deputy President of Kenya, respondent, and Honorable E.G.
My Lord, that matter is not before the court.
Your Lordship is being called. It is the court that should know whether it is before the court. We also want to know whether it is before this court.
My Lord, and my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether we can also proceed with it. When was it filed? It was filed on the 18th of October 2024, and it came up before Honorable Justice Mwamuye, who gave directions that it should come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. It raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Mwangi, the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, there are files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, Your Ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word Kerugoya. That is the file that was called out. And in order for the record of this court to be systematically accurate and easy to follow, may I with respect ask that we get clarity on this file that was called out, E13/24 of Kerugoya, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court this morning.
Senior Counsel Paul Ngute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk.
So I've heard. Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kerugoya before it arrived here with E0114. 0114. Then we have application number E0115, also from Kerugoya. That is application before this court. And then we gave direction on those application. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. If you there are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given directions pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them, maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we well guided. And perhaps also to state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kerugoya is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kerugoya, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we raised the issues? Just confirm on the question of the integration of that file with the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kerugoya or in Nairobi?
Let me deal with that. Lord, for the purpose of E572 of 2024.
That file is not before us.
That's all I'm only saying. I have heard the directions of the bench. The file is not before you. But I have instructions for the purpose of the work to take that petition was filed on 18th of October. The same day the Kerugoya file was filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours have orders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lords. This is a trial of the judicial. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, Madam. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me now. Thank you.
Lord, if you could mourn elsewhere.
My Lord, I had indicated to this honorable court that there will be at least 3 clarifications.
Just a minute, Mr.
Yes,
President.
Now, I think we need to get some things right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted, or the basis of that order, to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
just a minute, please.
Perhaps Justice, to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files will now be before the bench for months.
Yes, my Lord, I believe now I can be able to make the clarifications. starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first.
I was assuming quorum was.
No, there's a quorum in E013, which was consolidated in Kerugoya with E014. Let's take quorum on that file.
Your Lordship, is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I've not heard it. Perhaps it will be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My lords, I'm well guided, but when Justice Rima was giving the clarification, I never heard him clarify whether the Kerugoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kerugoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
Let me answer you. You said that records speak for themselves. And for record, matters which came from Kerugoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerugoya was already consolidated. Those proceedings which took place in Kerugoya consolidated these 2 files. So let that not be an issue here, please. On the directions issued on 11th by Judge Richard Mwongo, these were the directions. The petitioner in E014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the parties' response to the amended petition and petition E013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we may now raise the issues that we want to raise, particularly arising from the issues in Kerugoya. And I do not
will
know...
then proceed and take forum on it. They were consolidated, so we will not take further forum on this matter.
The Attorney General, I don't know, I had indicated to the court earlier, I need to raise some clarifications.
Section 7 of the Attorney General's Act.
You had already asserted it to speak. It doesn't override my right to represent my clients.
I'm repeating.
Can she then say her piece, I say mine?
Which matter are we now dealing with?
We have 0115. We have 0115.
My Lord, I wanted to say that the only matters before this court are the matters which had ex parte orders. The matters that came from Kerugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders.
I think they do.
We have E15.
E15 has
conservatory orders, but E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservatory orders.
I hope I can then be heard without further interferences. My Lord,
which is the matter, Mr. Kibe?
My Lord, I'm leading the number of advocates in this matter from Kirinyaga, E015.
Kerugoya 15?
Yes, Kerugoya number 15.
Kerugoya 15, yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit, in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on record. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice Mwini, the Deputy Chief Justice. Lady, my lords, arising from that are one, a legal issue and a matter of Article 150. My lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitutions. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may I
think I have a right to raise those issues. will have other right to respond.
Just give Mungai time.
Mungai.
I just wanted for good order,
Okay,
my lord.
is that a
Okay.
clarification, Mungai?
My lord, I am Mungai. I believe he will speak in response as soon as I'm done. Let me finish.
My lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Muigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my lord, the point that I wish to make is that I am acting for specific clients today, and as the court, I should be heard in silence. He will respond. And I dedicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would seek on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lord, under the former constitution, my lord, under the former constitution, we used to have a practice in which we had an officiary, a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. My lord, because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on a Saturday. And my lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My lord, for purposes of Article 165, I believe it's 4, of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
You would like us to discharge the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting And the thing is out there in the streets and the Republic of Kenya is that a special bench would be appointed for purposes of vacating the orders that were made. My Lord, I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that this issue we speak for the 190 and with a clear conscience. 2 things. My Lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state? As it used to happen those days before we had a new constitution. Issue number 2, my Lord, is this, the issue of bias. And this is bias by the Honorable...
I think, Mr. Mungai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that then does not have to do with those prayers. My Lord, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about 4 matters, one of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order and for purposes of us making this application, why would it be difficult even for this bench to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. My Lord, why I say as I go to see it, why I say this is important, is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So what, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my Lord, I urge the court to hold.
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is not administrative.
If you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I said down, the issue of that right is that we have had a situation before the National Assembly, before the Senate, it didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My Lord, sir, just to add on what my learned friend has submitted on, I will appeal.
With the permission of the presiding, I wish to say I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters, I can assure you. There is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds.
Senior Counsel Mwite and Counsel Ndegwa, you know, when you argue the way Mr. Mwe has argued, that court starts on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court start on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Murai. Let it not be an exchange between the court and yourself, because we are really very neutral party. Let us hear also from the other side.
We haven't really. In E015 in Kiruboka, the deputy president is the second respondent, first respondent in fact. We haven't said our piece, and Elisha Ugoya will be making submission. But my Lord, do give us this very weighty matter. This E015 in Kiruboka. The orders of your brother, Mr. Justice Mungo, were given at 4 p.m. Why did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give directives? Permit us to articulate these issues for the sake of the nation. We are not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
There is no other audience. Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call on any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite procedural. So what we have here are the three files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4, on the constitutionality of the constitution of this bench, to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the root of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That is why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued from us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called, in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectfully.
My Lord, with your kind permission, for the record, Dr. Kamoto for the fifth respondent in E015. I believe the reason we are here and the reason why we took forum is because we recognize that there are different parties to these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the audience of the court. So in this regard, my proposal is as follows, that each of the party whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectfully urge that we get an opportunity for each of the parties to ventilate the issues, because the fifth respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the nomination of a presidential of a deputy president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
My Lord, for the first interested party.
Mr. Lord, just a minute. I was about to interject when when counsel, Mr. not the other one.
Gachagua'S?
Yes, Mr. Debra was addressing, and that is exactly why I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which...
The application can only come after I have spoken.
We are now making an application, you respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4, to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject, to seek your guidance. My name is Mugomi, appearing for Professor Kindiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuations and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day, there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes. Yes,
my lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you are being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, Ndegwa and my lion friend Kibe, is that you are taking the court for a long ride and we're ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say? My lord, if I may, just to bring it to the court's attention, that
the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your Lordship's stand. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My notes, if it pleases the court, my name is Gachagua'S. I am acting in person. We filed an application on the certificate of urgency on the 8th of October, 2024. Before this bench was in panels on the 14th of October, 2024. Unfortunately, some of the credit we were seeking have been overtaken by events. My Lord, and today as the heard, our application has not been placed before you, and we are just concerned that our application will once again, events will once again overtake our application. My Lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my Lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Lady, for the 5th interested party in 15, can I just be heard for 1 minute only? My Lord Judge asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Mrima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity seat, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We add that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guide and Professor Gachagua'S, there will be greater order and coherence. And I thank you.
My Lord, is that an adjournment? Is that Mr. Goya applying for an adjournment? Because he's saying, and perhaps wrongly, that even the recusal application comes after the termination of the question when panel. If that be so, and they may leave, they normally leave court, they may leave, they left Senate, may leave court. We let them say whether they are applying for adjournment.
Is that the mark they normally leave court where the left Senate, my palatable in this court, my Lord? I need that.
No, because it's an adjournment.
No, is that the mark palatable for my Lord and my Lady? But because we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my Lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My Lord, I have no problem with withdrawing the remark, but the point is, it is a vague application for adjournment. Because Mr. Goya is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I'm answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I need to withdraw. I want him to withdraw first, my Lord, because I'm entitled to dignity.
Goya, I have no problem withdrawing. You're my friend. No, I have no problem, my Lord. I withdraw the remark, but there is practice.
Thank you. Let me now address the question as addressed. My Lord, Professor Genda was my teacher and my mentor for many years. I have no disrespect for him. I just want my own dignity asserted because I can't protect my client's dignity if my own is in question. But having said that, my Lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues, Kibe Mungai, and learned colleague, Mr. Njegwa, that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Grima asked, how do we move forward? I also had my learned mentor, Professor Gachagua'S, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Leadership again now on how to move forward.
Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light. It is now. They actually knew of it, and this, or should have, they would have found out. The letter which was written this morning, which we have, it was received on the, it was written on the 20th of October, has actually one pertinent question disposed whether the file was actually taken to the Chief Justice and at what time. So, they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to ECJ, possibly because of the absence of the Chief Justice. They will have to tell themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what you were told. That, as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fraction of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
My Lord, for the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues on the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the applications which have been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So, my Lord, what is the fuss about it? So, my Lord, my request is that the application, this speech by the petitioners, is solely meant to delay the business of the day. And, my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And, my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add, this court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
How we deal with death isn't just personal, but also cultural. For many around the world, honoring the dead can be a daily event with offerings and altars at home. Tech companies are creating digital options for these things. For example, a digital likeness in the metaverse that lives on forever. We've met someone that wants just that. Nicole Stacke loves life in the metaverse. Here she can meet friends and explore the world. And for when she passes away, Nicole imagines her avatar living on here.